In this video, I'll be talking with you about dealing with creditors. As a reminder, South Carolina law provides that creditors have the opportunity to bring a claim against the estate 8 months after the notice to creditors is published in a newspaper for the first time, or 1 year from the date of someone's death, whichever of those time periods is shorter. If a claim is presented against your loved one's estate, that claim is going to be on a form called the Statement of Creditors Claim. That is form number 371ES, and a creditor would complete this, letting you know who they are and what they say they are owed. This is typically done by our unsecured creditors. So we have two main types of creditors, secured and unsecured. Secured would be like the bank that has the mortgage on real estate, or the bank that has a lien on an item of personal property. As you know, if a mortgage is not paid, that real estate can be foreclosed. And if a lien is not paid, that item may be repossessed. Typically, your secured creditors do not utilize the claim process in probate court, but occasionally they will. Typically, what we see is our unsecured creditors utilizing this process. And even among our unsecured creditors, please keep in mind that they are not all treated the same under South Carolina law. So, for example, a funeral bill would have higher priority than a credit card bill. It's important that you pay your creditors in their priority order as set forth under South Carolina law. So if you do not have enough funds in the estate to pay all creditors, make sure that you are paying creditors in their priority order. So you would put all of your money toward your higher priority creditor before paying your lower priority creditor. Also, if you get several claims that are of the same category, but you don't have enough estate assets to satisfy all valid claims, you would need to prorate or divide what you do have available based on the size of the claims. So you wouldn't just pay out the one that brought the first claim or pay the one that has the smallest or the largest claim. You've got to be mindful of how you do it so that you don't incur personal liability. Now, when you receive a creditor claim, which of course is not going to happen to everyone, but we want you to be prepared if it does, keep in mind that the creditor will send this form to the court, and then we will send it to you for your review and response. If you're at all unsure about the validity of the claim, you need to investigate it. Look into it and see whether it's a valid claim by contacting the creditor, asking for more documentation, whatever may be appropriate under the circumstances. You're then required to respond in writing to the creditor, and this must be done within the time frame set forth by South Carolina law, which is 60 days from the date the claim is presented, or 14 months from the date of your loved one's death, whichever comes later. When responding to creditor claims, we have several forms available for you to utilize. If you pay a creditor, make sure that you get back proof that you've done so, and you can do that using the Release or Satisfaction of Claim form, which is one of our forms that's available online. And if we receive this, we'll know that that claim is no longer active. That's form number 325ES. If you're not paying a creditor, you have a few other options. You can always try to negotiate with a creditor, or if you're not sure that you're going to have enough money to pay a creditor, but you think the claim is valid, you're going to be utilizing this form, which is the Notice of Allowance or Disallowance of Claim. So let's say the hospital makes a claim against your loved one's estate for $1,000. You know that your loved one was a patient at the hospital and that the claim should be paid if there are funds available. So you would mark that first option that the claim is allowed. and you would submit this to the creditor within your response time period, which again is 60 days from the claim presentment or 14 months from the date of your loved one's death, whichever is later. If you have a question about the claim, you don't think it's legitimate, it's already been paid, it's the wrong amount, whatever the case may be, if you're not able to determine that it's a valid claim and you think it's invalid, you have some other options. Either you can mark that it's partially allowed and partially disallowed, or you can say that it's disallowed in full. Disallowing a claim is saying that you think there's a problem with the claim. It's not about whether or not you can pay the claim. If you disallow a claim, it then puts the ball back in the creditor's hands to then file a petition for allowance of that claim. If we receive a petition for the allowance of that claim, then we will have a court hearing on its validity and whether or not you will be ordered to pay it. Keep in mind, it may be a good idea to wait until the expiration of the creditor claim period before you start giving out funds to creditors or before you start responding to creditors, because it may be important for you to know all of the claims that you might be receiving prior to responding to the creditors that you've received. So sometimes personal representatives find it helpful to wait that 8 months or 1 year, whichever time frame is shorter, then review all the claims that have been filed, and then make the appropriate response. Just keep in mind, anything that you do with a creditor, you need to follow up in writing and submit that to the court. We cannot close out your loved one's estate if there are any claims that have been unresolved. Thank you for watching this video, and if you have any questions about handling creditor claims, please contact the court.